I think we can do after 5 minutes or no?
No, we are going because it interrupts in between. Na? So better we will go fast.
Okay. You can edit also.
Yeah.
Initial portion required, you can edit now.
Yeah.
Okay. No, two.
FIP participants, if you feel that your Zoom was exhausted, so we have YouTube link also. हमने एक YouTube link भी डाली है group में, which you can use it and you can go live from there.
Okay.
Vincent sir, good evening.
Good evening.
Am I audible?
Sir, good evening.
Good evening, sir. Good evening, everyone.
A very warm welcome from University of Mumbai too.
Thank you.
Principal of Bilamlani Women's College.
Thank you, sir. It's a pleasure to meet you all here.
Yeah.
Professor Mani, Dean of School of Law, Hindustan School of Law has arranged everything.
Good evening.
Very much, yes, happy to have our Dr. Manvinder Singh Pava. Namaskar. Namaskar. Yes.
So we can start.
Yes, sir.
Okay. A very good evening to one and all present here and a warm welcome. Today's resource person for the National Webinar on Legal Research Method, Professor Dr. Manvinder Singh Pava. Dr. Manvinder Singh Pava, an alumnus of IIM Ahmedabad, is an eminent academician with a rich experience of 21 years, which is a rare blend of academia, industry, corporate, consultancy, and research. His areas of expertise is corporate finance and business law. Besides his graduation, post-graduation, and PhD, he is professionally qualified as a company secretary from Institute of Company Secretaries of India. He is also LLM, MBA, and gold medal. Dr. Pava has conducted and delivered more than 125 special courses, which also include management development program for corporate and faculty development for a number of government institutions, including AICT, ICSSR, and UGC-sponsored FDPs. UGC HRDC refresher course orientation program throughout the country on research methodology, pedagogy, personal effectiveness, and work ethics, SPSS, and financial modeling. He has participated at numerous national and international conferences, chaired the session in India and also abroad, and his 70 research papers are published in referred national and international journals under his guidance, and 8 more are pursuing PhD. From last 6 years, he is working with Manipal University, Jaipur, and is presently professor in School of Business and Commerce. Our coordinator for today's function, Dr. V.L. Moni.
Yes. Good evening.
He is a professor and dean, Hindustan School of Law, Hindustan Institute of Technology, and Chennai from April 2019. He was former principal of Kerala Law Academy Law College, Thiruvananthapuram, Kerala. Adjunct professor of Savita University, Chennai for research activities. He is holding number of PhD guides 3 and number of LLD being guided under him was 3. His position in the university, he is a dean, member, academic council, chairman, board of studies, and many more to come. Our third resource person for today's program is Dr. Vincent Komraj. He's an associate dean, School of Law, Hindustan University, law professor for more than 30 years and senior academician in the field of law. All three resource persons are heartily welcome to our today's function of webinar, Legal Research Method. Generally, law is influenced by prevailing social values and ethos. Most of the time, law also attempts to mold or change the existing social values and attitude. Such a complex nature of law and its operation requires systematic approach to understand law and its operational facets. A systematic investigation into these aspects of law helps in knowing the existing and emerging legislative policies, law, their social relevance and efficiency. Keeping this in mind, Dr. V.L. Moni kept no stone unturned in the entire lockdown series by hosting number of webinars for the society. Dr. V.L. Moni, thank you so much for supporting our institution too, and always collaborating with our institution also. And keeping all these things in mind, Sir decided that we should have one more webinar on legal research method. First of all, when I heard the term legal research method, it's a new term even which I learned today only. But more or less, Dr. V.L. Moni can explain it in a better way. So without taking much of time, I will first ask V.L. Moni sir to kindly give introductory remarks. Sir, over to you.
Okay, thank you. So good evening. So today we are having the main keynote speaker, Professor Dr. M.S. Pava, who is from the Manipal, Jaipur University. And as we know, the topic we are going to discuss is on research methodology, legal research methodology. Actually, there's a lot of confusion, as has been mentioned by our previous presenter. What is the difference between research methodology and legal research methodology? When I was in an institution in Kerala, there was a professor who is also a PhD. And he happened to hear me discussing with some of my students regarding this legal research methodology and how it should be done and all that. Then he was coming to me and telling that, oh, there's no difference between the legal methods. It is all same for all faculty. And no, it is not so. It's little difference. And our Pavasar is a proper competent person to discuss on that, because he has been a person on law as well as on management, and he has got a degree on company secretary institute also. And as far as the subject is concerned, it's of interest for everybody, academicians, it's of interest for teachers, it is interest for researchers, it is interest for judges, it is interest for all students who are pursuing a course on any law subject. A research makes a subject more perfect because he has to go deeper, and understanding the principles and doing it in the proper way and the proper manner will increase the the knowledge base and the way to do the research in a proper way. So this is a very significant, important topic that need to be assimilated by each and every person who is involved in law and legal studies. So with this background, I am not going to make a very big talk on this matter, because we are having a lot of methods, a lot of techniques, a lot of research plans and all that. And I hand over my discussion to Professor Dr. M.S. Pava. You are welcome, sir, to present your views.
Yeah. Thank you, Moni sir. And after a long time we are meeting. We were there together in University of Petroleum and Energy Studies. So it's about you can say 8 years or so, 9 years.
Yes, yes.
We are
8, 9
in the
years.
same year again. Honorable Vincent sir, namaskar sir, and respected VL Body sir, Amlani ji, thanks for introducing me and giving me this opportunity to interact with the young researchers, faculty members. I can see about 68, 70 participants are there at present, 74 participants are there at present. I have also invited some of the research scholars and the students who are pursuing LLM from Manipal University, Jaipur also. So I hope they might have joined over here. So this is regarding, you have well correctly said that there is a difference between normal research methodology and legal research methodology. So we will be seeing it from that point of view, that how these are different and how it makes similarity and what specially is required, which makes it a special one. Besides this, I will also be highlighting something, that how one should, select a topic for the dissertation, because mostly I can see there was a lot of pinging coming up when I saw the messages. There were some students who were marking their presence. So I hope there are the students who are doing the research.
Sir, they are all teachers. Sorry to interrupt you. They are all teachers, and they are all faculty induction teachers. So there is
okay,
no
that's great.
student, all are
So
across India.
great, sir. One or the other way, they might be involved in research, writing research papers, something like that. So I hope this will make sense. And I would like this particular, mm, you can say, webinar to be an interactive one. So we all are from very far away. I mean, we all are sitting very far, but this internet, and you can say, or moreover, this a pandemic has been proved to be a, you can say, blessing in the disguise, that we are able to connect and contact with each other. And definitely we will, and if there is any question, you can raise the hand, and it can be taken up further over here, and we can just have a discussion. What I will be doing is that I will also be asking certain questions to all the participants, and accordingly we will proceed further with our presentation, or you can say with this particular discussion in this 1 hour, whichever has been allocated to me by Professor Moni sir. And let us just take me up. So before we start, I would like to just I would like to just ask that what actually is research and why we do research. Anyone from the faculty members or the students, those who want to answer this, can raise the hand. And yes, and I think the organizers can provide them the access to, those who will raise the hand can be provided the access to the to answer the question, so that the session can be made more interactive. Vincent sir, with your permission, sir, should I start, sir?
Yes. So they can unmute themselves and they can talk.
Okay, that's great. So any one of you, please feel free to interact and talk over here. And whenever you are answering something, it will be appreciable that if you can on your video also. Yeah. So anyone from you, why we do research? Anyone?
Sir, because of need of current scenario or present situation, or the need of society.
With your video, Dr. Priyanka? Yeah. Anyone else?
Sir, for the welfare of society.
With the?
For the welfare of society,
Okay.
for the growth of society.
Great. So we do research for the welfare of the society or for the benefit of the society.
Or for the growth of the nation.
Okay, growth of the nation comes very after certain stages. So what I feel is that we started from the charity starts from the home itself. So we want to have our own benefit first. So then the benefits can be extended to the, you can say, to the society, and then further to the state or to the nation and to the entire world, we can say. So that is what. So one thing is very clear, that it is for the benefit. Okay. So what type of benefit we reap, or what type of benefit we get from this particular research? Anyone else?
Sir, we get the academic benefit.
Okay, we get the academic benefit.
To make our life easy, for example,
Make our personal life
medicines.
easy.
Okay, so what type of easiness is needed in the life? You get more money when you get promotion and all that, your life becomes more easier. Is it so? Because when we are writing some good research paper and that is being published somewhere, so definitely our university provides some incentives also. A very good incentive is being provided. So we try to just incentivize ourselves by enlarging our own CVs. Like you see, if you see Professor Moni's CV, it is a thick CV, which is full of the researches which he has been doing throughout his life, and transferring the benefits of the study which one has done to others. That what is a actual benefit of research, you can say. So whenever we want to transfer the benefit of whatever we have studied to others, then we can say that we are actually disseminating something, or we are actually exchanging, or we are doing something for the society itself. Okay, so in law, what type of research we do, and what kinds of research we do in law, or why we do research in particularly in law? Because again, law is one of the discipline of you can say it is a discipline of arts, or you can say it is a discipline of something which is related to the society's social. That what? Yeah, Deepak Patel ji, want to say something? Yeah, Deepak Patel ji, want to say something?
I wanted to say, sir, the knowledge which is there are different kinds of research. One kind of research is done for getting the knowledge, to enhance the knowledge, and one research is done to solve the problems of the society, of the nation, and of many things. And one research we can say is done to do the experimental things. So I think there are different kinds of dimensions in the research.
Okay, actually you're not properly audible also anyways, but what I could understood is that there are various dimensions of research on which we have to do the research, and accordingly we choose the things to just proceed, or we choose the research to happen as such. Am I correct?
Yes, sir. Yes, sir.
Yeah, okay, Deepak ji. Fine. So let me just see what type of research we do is totally depends on that how we are proceeding further with the what are the objectives actually we have particularly in order to do the research. So it totally determines the type of the research we do at all. So I'm sharing my slide with you. I hope you will be. Please tell me if you are able to see it. I hope it is visible with my name now.
Yes, sir. Yes, sir.
Okay. So the purpose
Yes,
of the
sir.
legal research, if I just talk, because researchers actually do research particularly for their own good, for their own purpose. Why I will do research is because I want to do it. Now, what actually derives me to do it totally depends on the purpose for which I am doing it. Now, you can say that the purpose of the legal research can be or it can be two ways. One is academic, and another one is for practice. The research which is done by the lawyers for their practice is called practice research, or you can say the applied research part of it. Academically, we write the papers, we argue upon certain things, we debate on certain laws which are there in existence, and accordingly we do the research. So it begins with an analysis of the facts of a problem actually, and it concludes with the results of the investigation. So whatever problem we are having, we have to just find out the solution to it. And when we are finding the solution, the investigation of how we will be doing the investigation of the problem, that actually is the end to the legal research, or you can say. So legal research skills, these are there. This is something skillful. Like this is an art, and this is of great importance for the lawyers also who have to solve the legal case, and they do not actually just specify that what type of research they are doing, but there is something in their hand which they want to address, and that's why they want to do the research, because they have their client. Now that client is to be satisfied, the client need is to be fulfilled. If we all are teachers, and we might have gone for we might have prepared our students for certain moot court problems. So there is a person called researcher in the team. So that particular researcher has to find out the ways in order to come out of the problem. So that is, you can say, is a basic step in the legal research, is to find a noteworthy case governing the issue in the question itself. So whatever happens, in why we just expose them to the moot courts, because we want them to get exposed in the courts afterwards. And that's why we just give them a simulation. We give them a opportunity to present themselves. We make them uh, go in deep in the problem, in the legal problem, which they may practice afterwards. So as most legal researchers know, this is far more difficult, because what the thing is, it is very easy to say that we have to find a noteworthy case, but it is damn difficult to find that particular noteworthy case, because the legal problems in practical life are complex in nature. So we have to see that particular case from various dimensions as such, right? Whether a person is a lawyer, or you can see he's a paralegal person, or he's a law student, or he's a faculty, or whatever he is. So there is one essential part which is to be done, is a research which is to be done in a effective manner. So this particular research everyone has to do. Okay, we may have to do some research even when we are teaching to our students the subject like law, which is so dynamic that in corporate law it is so dynamic that it changes every day, sometimes that. Okay, so a person has to be updated with it, so he has to keep on doing the research, because whenever law is formed, there are ways to break it. People are there to break it off, and again, when it is to be taken in the court, the interpretation of that particular thing has to be presented in such a way that we have to favor our client. So every time we are doing research, so legal research has to be done in an effective manner, and effective manner means that the purpose for which we are doing must be fulfilled. So there are various ways, or there are various methodologies which can be there in order to perform a legal research. So different cases may be approached in a different ways, you can say. So there are various ways to be approached there are various ways to approach a similar type of case. Also there are various perspectives by which those case can be seen, and it is very, very important to know that what is our objective and what we want to fulfill accordingly, and so that it may be helpful for our client. So, or you can say from the practice point of view, if we see, this is the one aspect of the legal research, why we do legal research, or you can say why we do research in law. The academic point, on the other hand, is one by through which we want to come up with certain new things, some new ideas. Maybe some new laws may emerge out of our academic work. There may be some debates on the existing laws which are there, which are you can say promulgated by the legislature, and now these things are in existence. Or these days, sometimes the bills which are to be presented to the court are also opined by various people of the society. Those who are the stakeholders, they also give their opinion in order to go with that particular bill. So these type of academic, when we are debating on certain things, then there is some academic research, we want to bring some change out of it, then our purpose is the academic one. But once the legislature has been passed, the bill has been passed, it has become an act, now the things are in practice. Now for the client, for our own client, or for in order to make our own students understand, we have to do a applied part of research, and you can say we have to practice that particular part, and that's why we do research. So, and this is the point where it makes a difference from a normal social science, or you can say a normal social science research, and a legal research at all. Okay. So what the legal research is is still a question. So we can say it is a process. Legal research is a process. Process of what? Identifying and retrieving the information to support the legal decision making. If you carefully see the definition up till here, the definition says it is a process of identifying and retrieving the information. Okay, so this is common for all social sciences research also. But at the same time, when we are looking forward for the final objective, that is to support the legal decision making, then we can say that this is a legal research. So legal research is decision oriented. Its orientation is to support the legal decision making. So it begins with an analysis of the facts of the problem, and it concludes with the results of the investigation, you can say. So legal research is of great importance for lawyers also, for, you can say, for students also, and for even for the judges, those who are giving the decisions for them also. They also do research. And the most basic step in the legal research is to just find out the problem which is under the investigation or which is under the question. Okay, so that is what it is, and that's how we approach towards the legal decision making. So legal decision making even can be of you can say just deciding whether a given act or a given law is, to what extent it is useful for us, or to what extent it is not useful for us, or you can say, is it an infringement of certain existing constitutional rights, social rights, or you can say, or wholesomely you can say, the good of the society as such. Okay, so that what whenever we are talking about certain legal decision making or some legal part of the social science, then we say that it is a legal research. Now let us just see various types of legal research which can be done. So various types of legal research can be, you can say, first is the doctrinal and the non-doctrinal research. You can say doctrinal research is there, doctrinal legal research. Non-doctrinal legal research means once if the research is a doctrinal one, then the remaining all other comes under the non-doctrinal research. One more research is there, which is a comparative legal research. When we are not doing any of and even this comparative legal research, you can say it can be said as a part of the non-doctrinal research itself. Next is a descriptive legal research is there. Quantitative legal research is there. Qualitative legal research, analytical legal research, applied legal research, which I have just now talked about, pure legal research is there, conceptual legal research, and finally the empirical legal research. So we will be talking about these researches after a little bit of discussion with all of you. So all these types of legal researches are in front of you over here. So we will keep on doing. So first basic thing is the doctrinal legal research. So anyone of you, can anyone tell me about this doctrinal legal research? Anyone? Yes. Yes. Anyone? If you are aware of this doctrinal legal research. Yes, anyone? Yeah, okay. Should I proceed? Okay, fine. Those who are unmuted and those who are not answering or those who are not participating, please please mute yourself because it is creating a lot of disturbance. Mani sir, if people those who are not participating, if they can be muted, I think that will be very good. Yeah, thank you. Yeah. So what is I was asking, what is doctrinal research or what is a doctrine? And we all are students of law. we might be aware of what doctrine is. Anyone? What is doctrine? Yes. What is doctrine, if anyone can tell? Doctrinal research we are talking of. Yes, anyone? What is a doctrine? No one? Yes. Okay, what is doctrinal research? What is means whenever we say this, for example, you can say there are certain precedents which are created by the law. There are certain cases which are solved or which are announced. The decisions of which are announced by the legal courts, or you can say the court of laws. And on the basis of that, there are certain sayings which are there are certain thumb rules which are being created, and we say these are the doctrines, right? So whenever we are doing a doctrinal research, what happens? What actually is a doctrinal research? What is the purpose of doctrinal research? So the central question over here is what the law is on a particular issue, and what the law is and how it has been created on a particular issue will be you can say the purpose, or you can say to study that what the law is it comes in the doctrinal research, because there are various doctrines, there are various bases on the basis of which that particular law has come into existence. So it is concerned with finding the law, rigorously analyzing it, and coming up with a logical reasoning behind it, that why this law has been framed out and what is the law behind it. Therefore, it immensely contributes to the continuity, consistency, and certainty of law. Means from when it has been there, what were the circumstances when it has been created, and why, how consistently it has been there. For example, if you take the example of the Companies Act 2013, previously the Companies Act 1956 has been replaced by Companies Act 2013, and that too was not fully applicable as such. And then in the parts it was made applicable, and then also came the insolvency and bankruptcy law, which is in congruence with this company law which is in existence. NCLT was created, and it was not made fully functional at the time when it was created. It was made functional only after a certain time and in certain phases, in a phased manner. Why? Because this insolvency and bankruptcy law also came, and accordingly the applicability of that law was also to be made, and that's why the full functionality of NCLT was withheld for a certain period of time, and then afterwards it came in existence by the as the time passed. Okay, so there are certain limitations of this law, because when we are seeing that how the law has come into existence, what were the precedents, or what were the other parallel laws which have been created in order to support, or there are certain laws which are in contradiction with certain laws, to what extent it is in contradiction. So there may be certain interpretations of the existing precedents, existing laws, sub laws, or you can say the rules which are made thereunder. So there can be certain you can say certain relationship. It can be inverse, it can be direct. So in order to find it out, and it may be in such a way that it may suggest some good change in the existing law. Okay, so the particular limitation is that it is totally subjective. That is, it is limited to the perception of the researcher, far away from the actual working of the law, devoid the factors that lie outside the boundaries of the law, and fails to focus on the actual perspective of the practice of the courts as such. So this type of particular, why? Because certain precedents which has been announced by, or which has been declared by the courts, has to be on the basis of certain facts and figures. So at that time the situation may be different. In certain situations the court has given certain decisions, and that might not be to some extent in congruence with the existing legal framework. So a research is needed in order to come up with certain, you can say, a framework which actually tells that what was the law at the time, at the point of the time regarding a particular issue, because of which the existing changes have been there, or you can say why the law has been promulgated in order to address certain existing issues of the time. So that is a doctrinal research which actually makes the either it can question the existing law or it can support the existing law from various point of views. Okay, so that's what we will call as a doctrinal legal research, where we are able to understand and know what is law on a particular issue and what are the or you can say how we have come to that particular conclusion of that particular law. Non-doctrinal research, you can say everything else, as I have already told you, regarding those who are which are not you can say not doctrinal, everything else comes in the non-doctrinal legal research. So it is also known as socio-legal research, and it looks into how the law and the legal institutions mold and affect the society as such. So what is the impact? So know what doctrinal legal research says. Doctrinal legal research actually emphasizes on the existing laws, that why the law is and how the law is and what the law is there. But non-doctrinal, once the law is there, how it impacts the law, how it impacts the society, how the legal institutions are affecting the various aspects of the society, it works on that particular aspect. So it employs the method taken from the other disciplines in order to generate the empirical data to answer certain questions. Okay, so this is also full of certain limitations, and the limitation is that of the all other disciplines, whatever limitations are there with other disciplines except the law are the limitations of the non-doctrinal research. We will be talking about various types of non-doctrinal research which are there, and they will be having their own limitations, which will be the limitations particularly in that case in which that particular non-doctrinal legal research is there. Next is your comparative legal research. So comparative legal research is something which is related to, for example, I want to compare the Indian income tax with the income tax of the other income tax act or the income tax rules and regulations of the other countries. If I want to do that, so I have to do a comparative legal research. If you just see this, the concept of one-man company, which has recently come in our Companies Act 2013, is nothing but an outcome of the comparative legal research which has actually happened because this one-man company was already in existence in Singapore since very, very long. So similar things can be inculcated, seeing to others. What will be the legal implications according to our land laws? So these all things comes under the legal, you can say comparative legal research. So the purpose is it involves a comparison of legal doctrines, legislation, and foreign laws. It highlights the cultural and the social character of law and how does it act in the different settings. So it is useful in developing and amending and modifying the law which are already there in the land as compared to the other laws from in the other lands. For example, if you want to see, there are certain laws which comes under the list 2. List 2 is the state list. So every state is free to make laws on certain aspects which are given under the state list of the constitution. So in those so the states which have come up with certain good laws, the other state can also follow certain things, or they can also modify, they can also amend their laws seeing to the what is there in the law which has been formed by the other state. So this actually can happen through the comparative legal research, where we are making the comparison of our existing laws with the laws of the other state, our existing country laws with the laws of the other different countries, and we just want to come up with certain guidelines or with certain suggestions to the government, or with certain, you can say, voice up that we want to have certain laws over here because this is in line with the with you can say the other countries, because these they are serving well, they are being served well over there. So there are certain limitations because it needs a cautious approach has to be taken in blindly accepting the law of the another social setting as a base, because it might not act in the same manner in a different setting. So we have to see whenever we are making a suggestion out of certain comparison which we have made to the other countries, because they have some different social setup, the law which are there might not be applicable to our country, our land, or our state. So a caution has to be there, a caution has to be raised, or there has to be, we have to keep in mind that while comparing and making the conclusion for our current state of position or for our present situation of the law, there has to be some some caution which has to be kept in mind. We cannot just raise, or we cannot just put these things as such in the existing system, because this may backfire. There may be some opposition from the people, or we can say there may be or if certain dissertation topic is on which it is to be worked, is there may be some backfiring from the research committee itself. Okay, so these are the things which have to be considered as such. Now next is your descriptive research. Now what is the purpose of the descriptive research? The purpose of descriptive legal research, or it can be defined as a research method that describes the characteristics of the population or the phenomenon that is being studied. So it actually describes the you can say the parameters on which it has to be, on which description is to be done. So this methodology is focused on what of the research subject matter rather than why such research is there. So in other words, you can say that descriptive legal research, or you can say it actually focuses on the demographic segment without focusing on why of something else. For example, a lawyer wants to understand the crime trends of certain city, for example, Mumbai. Okay, so he will conduct a demographic survey of that particular region and gather the population data and then conduct a descriptive research on this particular demographic segment, and will try to understand that, okay, what type of law breaking has happened, or what type of criminal activity has happened. Let me just take an example of the cyber crimes. If you see the trend of these cyber crimes, the cyber crimes is being done mostly by those people, those who are from 16 years to 22 years. So this is the range of the people, those who are doing the cyber crimes. This is a report, you can just refer to it, that who are the people who are doing the cyber crimes. So this is the, so what has come in the mind is that there is certain demographic age, or you can say that age is a demographic factor, that who are doing this type of crime. So accordingly, the action can be suggested, because once we know the background of it, then only we will be able to suggest certain action on that particular thing. So this particular descriptive research tells us that what percentage of crime has been done by those people who are below 18 of age, or you can say above 18, or to certain you can say it can be distributed on the basis of the ages of the people, those who are involved in such crime. Now again, if I just want to know that the people, those who are involved in such crime, those who are, or otherwise those who are victimized by such crime, who are those, or what is the reason of their becoming victimized? Is there a proper awareness of cybercrime happening? And there are some people, those who are even doing that crime, even if they are not knowing that this is a crime. For example, let me just give you an example. Using a open access internet of someone who has not kept any password, it itself comes in a cybercrime, but nobody knows it. So wherever people find, oh, it is an open one, there is no need of password, they start using somebody else's data for their own purpose. this is a crime which should not, but people do not know about it. So, but this is ignorance again, is not a excuse for the law itself. One of the doctrine says this. So, but the problem is that now what is the research problem which has come out of it? That the people are not aware that this is a crime. So, what should be the solution? The solution should be that they should be given a proper training, certain messages to be provided at certain places, some logos to be created in order to make the people aware that what is crime and how they can save themselves from that particular thing. So whenever we are doing certain descriptive research, that actually tells us about the patterns which are existing. So once we know what the pattern is, then we can understand that what is the objective behind it. What is the mens rea? Is there any mens rea about it? The people, those who are doing this crime, are they aware about it? Or how can we just make it good? So that is the purpose of the descriptive research, you can say, or you can say descriptive legal research. So again, the caution or the limitation over here is that this particular descriptive research does not, it doesn't addresses anything about why the things are like this. It will only tell you the demographic report. Now whatever inference you want to make out of it, or you can say the why factor has to be the next step towards doing the descriptive legal research. Once you know what is what, then we can say why is that what happening. Next is your quantitative legal research, or you can say quantitative research, because in law also the quantitative researches are done. And let me tell you one thing, if you really want to publish your paper in a very good Scopus listed journal, the research should be to some extent a quantitative one, which actually depicts certain you can say legality, or sorry, certain decision making type of thing. Okay, so quantitative legal research is characterized as a descriptive legal research. I've already told you, because descriptive legal research actually describes the demographics of it. So it is one type of descriptive legal research methodology that attempts to collect a quantifiable information to be used for the statistical analysis of the population sample. So whenever we are talking about the qualitative research, it has to be something related to the statistics, or we are collecting some sample out of the population, and then we are inferring the population on the basis of that sample which has been collected. Now the problem over here is the legal problem. That's why it can be called as a legal quantitative research. So it is a popular research tool that allows us to collect and describe the nature of the demographic segment, and then we can proceed further. Or you can say quantitative legal research, in other words, you can say collect the information from the existing and potential data using the sampling methods, like you can say online surveys, you can use online polls, or you can go for questionnaires. Even certain data can be collected. Okay, and it results in a numerical form of type of thing, which actually can be used for a statistical analysis. So after carefully understanding of these numbers, it is possible to predict the futuristic type of thing. Or you can say you can have some regression analysis in order to predict that what can be if the situation remains same, what will be the future position of this particular law in certain state or certain country at certain point of time. So for example, you can say that a survey can be conducted in order to understand, you can say, the turnaround time of the cases in the high courts. Okay, and how much time it takes from the time that the case is filed and the judgment is passed. So this is also a type of research in which the research problem is nothing but the legal problem, because justice delayed is justice denied, and that has been happening in India. We all know it very well. And a complainant satisfaction survey can be done. To what extent, for example, from the consumer courts, those who have filed the consumer complaints, to what extent they are satisfied with the decision of the case which has been happening in the consumer forums. So such type of questions, if it is asked, or you can say such type of things, if we can do, it can be a it can be quantified, and a decision can be taken. Because once you have some idea of the quantification, then only we can tell our authorities to take a decision on it. So this is what it actually tells. This quantitative research is related to quantification of the existing data. Okay, so limitation is that of the social quantitative researches are there, because here what we are doing is that we are entering the population on the basis of the sample. So there are various limitations of collecting the sample also. There are various limitations regarding the source of the sample, the limitations about what type of instrument we are using in order to collect the data. Is the data authentic? Is it valid? Is it reliable? So various type of things are there, and each and every tool which we are using, suppose we are using chi-square test, we are using a t-test or ANOVA or a regression analysis, even sometimes we use correlation analysis also in order to infer certain things out of the existing data which we have collected regarding the law. And on that basis itself, these all tools are having certain limitations.
बस थोड़ा सा बच्चा है तो ये लेक्चर चल रहा है उसकी 4 लाइन बनाना है, लिखना है, वो टाइप पे चले. हाँ.
So these all are the limitations which are there in order to just address the problem of the quantitative research. So next is again qualitative research. You can say there is again a purpose for the qualitative research. And what is the purpose of qualitative research? Is that qualitative legal research is subjective form of research that relies on the analysis of the controlled observation of the legal researcher. So in qualitative research, data is obtained from relatively small group of subjects. Okay, so data is not analyzed with the statistical techniques, but we usually we just have it in a narrative form. So there are certain methods of doing it, that whenever we are going with the qualitative research, or you can say it adopts a method or a study by which actually generates certain queries. And these are the 4 type of things are given over here, because I have shortage of time and the space and the limitation regarding this. I've given only these 4 types. One is, you can say, a grounded theory approach, you can say grounded theory practice, narratology is there, storytelling and ethnography. These are the various tools, or you can say the methods of doing the qualitative research as such. So what the grounded theory is? Grounded theory actually tells that there are certain researches which are, or you can say there are certain observations which are grounded in the data which is developed by the time. So various data or the sources are used in order to take out the qualitative aspect of that particular problem which we are having. We can go for review of records, we can go for interviews, observations, surveys. You can even analyze the trend on the Twitter. You can analyze the trend on the Facebook regarding the problem which is there. For example, the recent problem of farmers are there at the border of the Delhi. So what is that particular thing which is coming again and again? So what is actually, so because this particular thing has never happened in the recent past. So there is some solution inside that particular wave with which the people, and how not only farmers, I think almost everyone might be affected to one or the other way. There may be some people, those who are against it. There may be some people, those who are in favor of it. So if we want to analyze the trend, that what actually it is and to what extent it has affected the general public of the country, we have to go for certain grounded theory approach. Next is, you can say, it is a narratology. So it refers to the theory and the study of the narrative and the narrative structure. It shows the way in which the results affect the researcher's perception. So, for example, a person is having certain perception itself. So narratology actually it develops a theory. So whenever a person is narrating something, whenever a person is saying something, or whenever you are asking something else, some other person to say, or you tell something about whatever hypothesis a person has prepared, so that narration may authenticate the problem. In the same way is the storytelling, because storytelling particularly is a research which is also used as an applied form of research by the police for investigating the crime scene. So people, those who have actually seen it, they will tell them to just narrate the story, or you can say they will ask them to just tell the story about the event which has happened. So on the basis of that, they will try to form certain inferences that who is saying what, means who is the culprit can easily be taken out by this storytelling type of, you can say, story listening type of thing. Another is, you can say, ethnography. Ethnography is used for investigating the cultural differences. So whenever we are making any law regarding certain culture, or you can say either it is for or against the culture, then we have to use the ethnography, or you can say ethnography is used for investigating the cultures, collecting and describing the intent of the people, and to help them develop a theory. So once this, so what the qualitative research does? Qualitative research actually tries to develop a theory or a statement or a hypothesis which can be done using grounded theory approach, narratology, storytelling, these ethnography. So these all things helps us. Let me just give you the example of this, the act which is called Narega before and then Manrega afterwards, because Mahatma Gandhi name was attached afterwards with this. So what was the origin of it? How it came into picture? So that was something which has come out of the ethnographic research. Just take an example of this right to education. This has also come up with a qualitative research method, and which has actually, you can say, from one or the other way, it has come up with interpretation of the existing laws, with keeping or setting aside the education as such, that this is also one of the right which has to be included, and that's why these all the laws have come up. So again, it is also having the limitation as that of the social qualitative research, the various types of, like this grounded theory, narratology, each and every type of research is having their own limitations. So they will also be affected with the same limitations. Next is your analytical legal research, or you can say the research which is the purpose of which is making a qualitative inquiry. So this is again an analytical one. So sometimes it is often said that analysis or analytical is another name of quantitative research. It is not so. Analysis can be done for the existing theory also, and with the numbers also. So it is a specific type of research that involves a critical thinking skills. May it be a qualitative one, may it be a quantitative one, but whenever a research is there which actually makes you think critical, or you can say makes you think in an evaluative manner, then it can be said that that particular type of research is a analytical research. So actually this is used by the lawyers in order to address their own cases. So lawyers often use this as an analytical approach to their legal research to find the most relevant information out of it, which can be used in the court of laws by them. So from analytical research, a person can find out the critical details to add new ideas. So whenever we are going critical, we are generating certain ideas which can be related with the existing laws, which can be related with the precedents which has happened, and it can be presented in front of court of laws in order to substantiate it, the cases. So this happens when it is a qualitative in nature, and when it is quantitative in nature, then also the analysis can be done. For example, if we take the crime rates in India from 2010 to 2020, so if we try to see the trend of the crime rates in India, and we try to explain it, and we even can see that these crime rates there can be ups and downs in these crime rates during that particular period of time, and we want to substantiate it, that what were the reasons of high and the low crime rates in India or in a particular state, then we are actually trying to do a analytical legal research, and on the basis of that analysis we want to draw certain conclusion, and we want to have some checks and balances. Okay, so again, the limitation of social quantitative research will also be applicable over here in the case of analytical, and the social qualitative legal research will also be applicable. Depends on what type of analytical legal research we are doing. Next is your applied legal research. So when we are talking about the applied legal research, I've already told that it is having a straightforward practical approach to the case a lawyer is handling. Okay, so it is totally dependent on that. So the purpose of this applied legal research methodology is to find a solution to a pressing practical problem at the hand. So it involves doing a full-fledged research on a specific area of law, followed by gathering information on technical legal rules and principles applied, and forming an opinion on the prospects of the client in the scenario. So here the client is in picture. So this particular thing is related to the practical legal research. I have told about the academic legal research and the practical legal research, or which is the applied legal research. So it is I have already told you that this is something related to handling the case as such. For example, if the client is an employee of an organization and it is fighting against some wrongful termination of the contract, which has recently happened in this pandemic situation. Also, there are n number of cases regarding retrenchment, regarding the layoffs by the companies, and the lawyer has to find the policies which have been violated by the companies for retrenching them. So accordingly, and what are the provisions of the law which have been which have been infringed, or you can say which have been broken, or which are taken into which have not been taken into account by the employer. So these all things will make a proper appropriate case in the favor of the client. Okay, so that in that case we use the legal research. So limitation is that this is different in different cases. So the same, it cannot be actually, you can say, generalized. So this will be different in different cases, or it will be situational as such. Next is your you can say it is a pure legal research. So pure legal research actually is you can say the research which is basically the legal research focuses which on the generalization or formulation of a theory. So whenever we are trying to formulate something and we want to replicate it on the general public, then the purpose, and when we do the research with this purpose, then we can say that the research is a pure research. Normally pure research involves a cause and effect relationship. Okay, so this is what the pure research is, and the limitation is that the researcher doesn't focuses on the practical utility. It actually emphasizes only on the situation which is given, and on the basis of which he wants to create some generalization, or you can say he wants to formulate a theory, because theory itself is, once formulated, it itself is surrounded by various limitations, but those limitations are once ignored, and then if he wants to come up with certain things, then it will be called as a pure research, because he may be having a logic of you can say logic of supporting, or you can say against that particular theory. For example, if you just take that if we conduct a basic research on the illiteracy which is leading to unemployment, and unemployment further leading to the crime, so there is a cause and effect relationship, or there is the theory which has been evolved, but these theory will not be applicable everywhere, that the illiteracy is actually causing unemployment. There are people, those who are illiterate, and they are not unemployed. They are already employed and they are not doing any crime. But this actually tells that the illiteracy leads to unemployment, and unemployment actually leads to the criminal activities. And this is being you can say this has been made universally applicable also to some extent given certain situation, but this is not applicable always. So practical utility is sometimes compromised in case when we are doing the pure legal research. So whenever what we mean by this limitation is that once these limitations are there, and if we keep in mind these limitations, the mistakes which otherwise has happened may there will be a less chance of happening those mistakes. Further, the conceptual research, the purpose, and or you can say the definition, and that it is defined as a methodology wherein the research is conducted by observing and analyzing already present information on a given topic. So whenever certain information is already there, we just try to apply our concepts and we just try to come out with that. So they are generally resorted by the philosophers or the thinkers to develop certain new concepts, or you can say they will try to reinterpret the existing concept. But because what happens, the situation doesn't remain same. So the situations keeps on changing. So whenever a law which has been formed or which has come into existence, there are situations which have changed. The society is changing, and we have to apply those conceptual things on the law, that whether this law is applicable to us or not. So conceptual research doesn't involve any conducting of any practical experiments, but it is related to the abstract concepts or the ideas. So, for example, you can say the ancient law which were made by Britishers during their rule, we have accepted those as such for a certain period of time. But after a certain period of time, we have to change them according to our needs and the needs of our society. So these things, the conceptual legal research actually points us out that what type of concept has been developed and to what extent it is matching to the existing legal laws, or you can say the laws which are there in existence now. Next is your empirical research, and this is the last, I think, the last research itself. So empirical research, the purpose of empirical research, you can say, is or you can say it describes or investigates the role of the legislation, regulation, or the legal policy and the other legal arrangements in the society. So it acts as a guide to the lawyers, to the law students, to the professors, teachers like all of us, on how to do empirical legal research covering the history, matters, evidences, you can say the knowledge which has grown by the time, the links of the normativity or whatever. So, for example, if we say the pharmaceutical companies use the empirical research to they try to find out that whether a specific drug is on the control groups which are taken randomly, to what extent it is applicable. For example, the vaccine for the COVID has come. So to what extent this vaccine was applicable, or to what extent this vaccine was successful. So such type of research is called empirical research. So when we are talking of empirical legal research, we can actually, before passing any law or before making a bill act, these type of research can be done, or you can say opinion can be generated from the people, and we can ask them to what extent they are they are agreeing upon certain provisions of the law, and on that basis you can say the empirical evidences can be collected, and we can just see to what extent this law is acceptable. And further, it is also a multidisciplinary type of thing, because we are using statistics, we are using various other things, so various other aspects of law. For example, tourism law. Tourism law is something which is a new concept. We do not have any laws or any branch such as a tourism law itself. So this can be one of the idea on which if somebody wants to work, I can collaborate with them to just work on this, developing or coming up with certain tourism laws. Tourism laws are there in other countries, so that can be. So there are certain aspects, or there are certain approaches from the social sciences, or which are or from the evolution of the studies, and we can come up with certain you can say a proposal which can be given to the government on certain things which are not in existence. Or the empirical research, some you can say applied empirical research, you can say can be done, or certain decision oriented research can be done, which can give a path to someone to just work on it as such. So one or the other way, if we see, so the legal research as such is a systematic, or you can say it is a systematic understanding of the law, while keeping in mind its advancements happening from the in the day-to-day life, the law which usually acts within the society, and they both have the impact on each other. So each of the kind of the research methodology has its own value, we can say. So however, while understanding the research, a researcher might face some hurdles, but they can be avoided if there is a if he plans research properly, or you can say if he plans the process of the research in a better way. I think this is all. Actually, I have some more other things also, that how to choose a research topic. So there are various things that what can be used in order to choose a research topic. But I think there is a shortage of time. I should stop here. Otherwise, the further part of whatever I have discussed now regarding the types of research, there can be choice of the research topic also, and there can be a process of legal research which if systematically followed, we can just come up with certain concrete research which can be done, from the selecting a topic to how to write a report. So I will stop over here, and I will share these slides with all of you in case you need it, or if these slides will be helpful for you in one or the other. Thank you all for patiently listening me. And
Thank you, sir.
Thank you, sir. We will have one more session ahead later. Now I invite Professor Vincent Comrade to talk, and after that we will have discussions.
Okay.
Professor Comrade, sir, please.
Thank you, sir.
Thank you very much. After the scholarly presentation covering the entire aspects of legal research and the different types of legal research by the eminent scholar Manvinder Singh Pava, Professor Manipal University, Jaipur.
thank you, sir. I'm just looking forward for your building.
Who has actually enriched me with the knowledge and experience that he has acquired throughout in the research methods in legal research especially. He has explained the 11 types of research in an extensive manner, so that I am left with a little option to just wind it up within a short time with regard to certain complementary aspects to our professor's presentation. So I came across a quotation about research. American sociologist Earl Robert Bobby, who says research is a systematic inquiry to describe, explain, predict, and control observed phenomena. So when I was analyzing this, everything which is actually given by our professor earlier through the different types of research and approaches for ascertaining what is actually legal research and the types of legal research and how we can go ahead with the different methods of legal research, we could find this particular quotation: to describe, explain, predict, and control. I must accept that Dr. Pava's background, everything, when we have a discussion in the Hindustan School of Law, Dr. Moni sir used to share the happy moments he had with Mr. Pava when he was there along with him. And he could not forget many things. He used to narrate everything to me. And I am looking forward actually to meet him in person and have a few days with him because of his hospitality and so many other things he was explaining to me. So today is actually a day for Mr. Pava, Dr. Pava, and I am just an addition, a kind of just a complimentary person. So here, when I come across this legal research, how this is going to be different when there are people like our Chief Minister here in Tamil Nadu making a presentation on the basis of a generalization relating to the farm laws. Lakhs and lakhs of people are agitating in the borders of Delhi. And Dr. Moni sir said, it will be apt and appropriate to bring a person who represents that sentiment and the emotional link with such people. When we are asking him to present and enlighten us in the South, No, we will be twice blessed. The blessing is related to his opinion about what is going on, how we could approach these farm laws. And another one is the extensive knowledge he has acquired in the different research processes as well as types of research. So here, I must accept that when you or anybody try to go for a research in legal research method, so we have to adopt a systematic method. The basic thing systematic is there shall be accuracy of data, and there shall be rules and procedure which are to be integral part of our research, and there shall be ethics, a code of conduct while making observation as well as drawing conclusions. Now, this is actually the main thing that every researcher in a legal research field must adopt for the purpose. Mainly, we have been doing research in PhD, in law schools and law universities. So here it is predominantly doctrinal. Most of the research degrees that we get is through the black letter methodology only. We don't go for something extra. We focus on the letter of the law and not on law in action. So this difference we have to now take forward for the purpose of better access to the different research methods in legal research also. We normally compose of a descriptive and detailed analysis of legal rules found in our primary sources like case laws, statutes or regulations, or even to some extent customs. Apart from the traditional methods, now there are different methods needed for approaching law through the jurymetric point of view and through the different aspects of judicial impact assessments, and then approaching law in the socio-legal perspectives. Now we know that whenever a person gives his generalized opinion about the law which has been made, we know that when sudden new laws are brought into the legal arena, I don't know whether proper legal impact assessment has been made or social impact assessment has been made. No, this is the thing that I was thinking about in the case of these farm laws and so many laws. Whenever a sudden announcement is made, what is going to be the impact of such an announcement or such a law on the people of this country? When sudden lockdown is there, I don't know whether the impact assessment with regard to the migrant labor, what will happen to them, how could they sustain themselves in the particular place of their abode, was not analyzed. That is what, in my humble view. Now, likewise, in the farm laws also, when our chief minister went on the stage and proudly proclaimed that only with the main purpose of completely removing the intermediaries, this law has been made, and it is going to be beneficial to all the farmers in this country, and we are going to achieve great growth in both agricultural sector as well as the financial sector. The GDP growth will be there. We know that there can be GDP growth. We know that the farmers can have better access. But when the chief minister announced that the entire intermediaries are removed from the arena between the agriculture sector, that means, the farmers and the customers or consumers. Now that is a statement which is just a generalization, which is not supported by the real analysis of the accurate data available. When people from Bihar, farmers from Bihar say something, the impact of such removal of small intermediaries and bringing in big intermediaries. No law says the entire intermediary system is removed. In the place of small brokers and intermediaries, we are bringing multi-million-dollar powerful intermediaries in the form of corporate sector. This is the only difference. Intermediaries are not removed. There are intermediaries. The law itself, when our Dean, Professor Moni sir, was making a presentation in the Aligarh Muslim University on the formulas, he said, the word intermediaries, how they are also permitted to play their role in the farm sector is mentioned in the laws with regard to the contract farming, with regard to so many other things. So point is that whenever we make an analysis of a law for the purpose of doing research, we must also approach how the social auditing of the law is to be made. Now, this is to be the additional point that I want to make, because whenever we are going to make suggestions for new law reforms in law, we may have to have analysis from different approaches, from the monodisciplinary approach that we are mostly adopting. We have to go to the transdisciplinary approach also, because the law cannot be a silent spectator or a person which is actually living in an excluded or secluded citadel. Nothing in law is alien. Nothing in this world is alien to law. Every subject which is human in nature is to be analyzed from the point of view of law. So transnational approaches, we have to dissolve the boundaries between conventional disciplines and the real world situation has to be analyzed. Now, because the world is changing fast, the legal research has to also adopt certain innovative modern techniques of legal research for the purpose of clearly analyzing. Our professor has also mentioned about the multidisciplinary and interdisciplinary legal research. Now, that is now coming to stay. In almost all the universities in the South, we have found almost all the research scholars who want to cross the boundaries. They wanted to have an interdisciplinary approach and they want to have multidisciplinary approach. Now, then only it is possible for us to analyze how a researcher can do justice to analyze law in action. See, empirical research, when professor was explaining that, he said how the particular researcher will be confronted with the impact of law on the society. The judicial impact assessment, the Vellore case has clearly made an assertive statement that before a judge passes a judgment, he must also take into account the impact of such judgment on the people, on the real stakeholders and the ultimate groups of people who are going to be affected by the judgment. Now, this type of premonition and prognostic approach is to be there, not only in judicial decision making, but also in legal research. Normally in US and other places, the judicial decision making is also a sequel to legal research analysis. Here also, our students know, our professor has clearly said, even a moot court competition has a researcher there. So from the stage of the students in the undergraduate level, we are going to have this type of approach in almost all the law schools. I am proud and I am very much privileged to be with Dr. Manvinder Singh Pava, because I think I am assured that the students of the Manipal University School of Law, their Jaipur, are blessed by the presence of Dr. Manvinder Singh Pava, because of his extensive knowledge and capacity to analyze the nook and corner of the research process will assist the students and the research scholars in the university to make further inroads into the areas which are actually required in the modern perspective, where the society is moving fast, the world is changing fast, and the Indian conditions are completely dynamic in the sense, and the research scholars have a very great role to play. I have taken some time, but Professor Dr. Moni sir said there is going to be some discussion, interaction, and other things. I don't want to stay in between the so many chat box presenters there. They are actually asking so many things from Dr. Pava. So I rest over to Pava and the organizers for the interactive session. Thank you very much. It's a privilege to be amidst your midst today evening. Thank you very much.
Sir, thanks for the nice words. Even brother, I am privileged to have a blessings of you today, sir. Thank you very much, sir. And I'm looking forward to meet you personally too, sir.
Thank you.
Sir.
Thank you.
Thank you so much, sir.
Thank you.
We hope in this backdrop, the present webinar on legal research methods intends to acquaint the faculty with scientific methods of inquiry into law. With this note, I would request Professor Moni, sir, to kindly say a few words about today's webinar. Moni, sir, are you there?
Sir, kindly unmute yourself, sir. We are not, you're not audible, sir.
Yes, sir.
Yeah.
Okay. Good evening. I think today's session was very interesting, and we are embarked on the various aspects of research, from historical research to the modern technical analytical research, and to the latest survey, and to the applicability of practical research, which has been very important for the researchers from various points of view. And I think it is appropriate for us to give time for Professor Pava to answer the questions of students, then conclude.
Participants, any questions? You can ask sir directly, or you want to write in the chat box, you can type it.
Better put in chat box, and Pava sir will reply, then we will conclude.
I am receiving only thank you, thank you.
Okay, that shows that the session has been excellent. It has reached to great extent. I think we will plan one more webinar to have more aspects which has been left out, and we'll be planning.
Yeah. What else can be done is, sir, I can take up a research paper and will explain the various aspects that how a good research paper can be written and how it can be, sent for a publication in the Scopus listed journals, and what are the journals which we can highlight, particularly on various laws. You can say on various aspects that can make that
so
I can.
We will be planning with that's in the next session.
Anytime, sir. Anytime,
okay.
Sir.
So I think with this we can conclude today, since we are not having much questions, and we are
On
very
behalf
thankful.
of Company Law Society, Thiruvananthapuram, Kerala, and from Professor Moni Venkat Lakshman, myself, Dr. Jitendra Ayakar, Principal of Yalamlani College, give a formal vote of thanks to Dr. Manvinder Singh Pava, as well as Dr. Vincent Komraj, sir. Thank you so much, sir, for sparing your valuable time for this entire webinar series. Foremost, the faculty members of the HRDC, UGC, Rani Durgavati Vishwavidyalaya, Jabalpur. They are all with us today for this webinar. And the students community and some faculty members from University of Mumbai. Thank you so much, everyone, for patient listening. And we wish that we will continue in the next session also with you. Your enlightenment word was highly appreciable by the participants. Thank you so much.
Okay.
Thank you, sir.
We're sending you a feedback form in the chat box. So participants, kindly fill that feedback form to avail an e-certificate of your participation.
Yeah, and sir, please, one request, please share that feedback with me also, so that if I have to work on it, I will definitely work on it, sir.
Yeah.
Thank you, and thanks, Vincent, sir, and thank you, Amlani ji, and special thanks to Moni sir, who has given me this opportunity to interact with everyone over here. Thank you all. Thanks a lot.